The Committee on Land, Agriculture, Environment, and Procurement Reform brings this oversight hearing back from recess. It is 5 p.m. on Thursday, May 24th, 2018. Present with us this evening is, to my right, Speaker B.J. Cruz. To my left is Senator Frank Bloss-Uggen. The purpose of today's oversight hearing, and Senator Tilina Nelson is also here with us this evening. The purpose of today's oversight hearing is to obtain information related to the Chamorro Land Trust Program compliance with the rules and regulations adopted by Public Law 23-38 and the Chamorro Land Trust Act found in 21 GCA Chapter 75 relative to residential and agricultural leases. The respondents for tonight's oversight hearing are the CLTC commissioners and the executive director, Mr. Michael Borja. Present this evening, of course, is the chairperson, Pica Fejeran, along with other commissioners, Mrs. Amanda Santos, Mr. Austin Dueñas, Ms. Chantel Teixeira. Notice of this oversight hearing was provided to senators, stakeholders, and the local media in accordance with the open government law. To start with the oversight hearing, I would like to establish the rules of engagement. The Chamorro Land Trust Commission chairperson will provide the opening remarks and will proceed with testimony from the Commission in response to the numerous questions that have been raised, the concerns that were raised at the oversight hearing earlier this week, and also information that has been raised in the media. Questions will be allowed from the panel following the testimony that's provided by the Commission. And however, to make sure that every senator gets an opportunity to ask the questions that they have, I'm going to do a round robin, and basically each senator will be able to ask one question per round, and we will go for as many rounds as necessary in order to be able to get the questions asked. So with that, I would like to invite the chairperson, Mrs. Pica Fejeran, and you can go ahead and bring up whoever you want to join you at the table. Also present with us is Vice Speaker Therese Terlahi and Senator Regine Biscoli. Madam Chair, whenever you're ready.
Half a day, Senators. Before I begin, I'd like to ask Commissioner Amanda Santos to provide testimony.
Is this testimony on behalf of the Commission?
Yes, as the longest tenured commissioner, I wanted to yield the floor to her to get the discussion going, if that's okay. It's a short testimony.
All right, I will defer to your request.
Thank you.
It's okay.
I'm deferring to the chairperson's request.
Buenas, senador and senadoras, jambisitas. I'm going to go back now to English. Today, we board members come before you, legislative body, to be honest with you, what was going on in awarding leases to Chamorros who applied for land was so appealing and worthy. I have no objection on some who were bypassed, because I do feel that 20 years is long enough to wait, especially for a landless Chamorro who desperately needed a home for their family. In that period of time, my husband and I rented a house for 20 years to house our 9 children. I don't blame these Chamorros who cried and yelled for mercy because land trust is taking their sweet time, going over rocky lands which was not enough, not even suitable to build a house or plant vegetables to feed their family. I myself cried after hearing our tomorrow's cry, complaining enough is enough. I am a mother of 9 children, 30-some grandchildren, and almost 50 great-grandchildren. After 20 years of renting, we bought a house in Barrigada, and I do house most of our grandchildren because their parents could work and buy a house to shelter them. As a grandmother, I am proud to say what I accomplished in the years after 20 years renting a house to house my family of 9, 4 girls and 5 boys. I hope and pray that Land Trust could correct all the discrepancies affecting our people today and to go on to award all applicants on a first-come, first-served basis as planned. Mrs. Amanda L.G. Santos, board member for 8 years in the Tomorrowland Trust. I thank you.
Thank you very much, Mrs. Santos. Mrs. Farron.
Sijus Masi, Hafade Todu Hamzu, na Anhu si Pika Farron. Itatahu si Frank B. Rosario, Zani Nanahu si Janji. Tau Tau Sinahanya, Lo, Sumasagazu, Giza Totu Kenyatta. Sijus Masi Committee Chair Senator Atta for calling the second public oversight hearing for the Chamorro Land Trust Commission. 2 years ago, I appeared before this same committee for my first confirmation hearing for my appointment to the commission. I shared with the committee my desire to give back to this beautiful island that raised me and put my education and experience as an urban planner and environmental protectionist to use for our people. In the 2 years I have served on the commission, we have come a long way. When I started, we were incomplete. And just last year, we could not meet for 3 months because of lack of quorum. Today, I'm happy to report our commission is full. We now have 5 minds working together to provide direction and guidance to the trust. As commissioners, we hold public meetings once a month, and more often than not, they would last the full time, from 1 p.m. to 5 p.m., sometimes even later. From the first meeting I attended to the last meeting we held, the commission meetings were a place where we addressed CLTC issues that were out of the norm. We would review individual cases where the administrative director needed commission direction to address the issues. Many of these issues had been around for years, but only finally being addressed in recent times. These meetings also included updates on the regular residential and agricultural leasing activities. We saw leases going out and we saw progress. Every commission meeting begins with a public comments session, and the public comments we've heard over the years on a regular basis included much of the same issues that were presented at this past Tuesday's public comments oversight hearing. People are still waiting. Our lessees cannot access their property. Our lessees have no infrastructure and cannot afford to get infrastructure out to their property. We've heard from lessees or applicants who are still suffering from the wrongs done to them in the past by employees of the commission who abused their roles and subjected the lessee to unfair treatment. We've heard from applicants who are frustrated at the lack of response from the office. We've heard from applicants and lessees who are confused, who are desperate, who are asking for help. Puti ikurasonhu. At these commission meetings, I've also learned of systemic issues that our program is faced with. We have a team that is understaffed, and the staff was always trying to keep up and get to everybody. We're working with a 23-year-old list of applicants, some of whom we cannot find. We're working within a 23-year-old system. We lacked the ability to comprehensively plan or manage our land and leases. We were constantly having to correct the technical errors of the past while also trying to move forward. Since before I was confirmed onto the commission and throughout my tenure, I have met at length with the administrative director. I have met with the staff, all together and individually. From every meeting and interaction I have had, I saw that our team was trying their best and wanted to do things right. But we're operating within a system that was fraught with issues that have been building up over the last 23 years. And they were working to try to fix those issues while at the same time under immense pressure to move the program forward and get leases out to our people. Over the last several years, under the leadership of the administrative director, our accounting system has been stood up. We've had annual audits that did not reveal any deep systemic flaws, but instead drew out a handful of specific issues that the commission has been able to resolve. I've asked everyone working at the CLTC, how can I, on the commission, help you do your job better for the trust? I was not blind or deaf to the cries for help from our applicants, from families just like mine who are just asking for a piece of property to build a home or farm on. If you could imagine, you're standing in front of this huge Otsulati, which is the CLTC program that's been in operation for the last 23 years, full of challenges, but held together by the staff and directors that have come before us and are working today. We see the flaws in the Otsulati. We see some pieces chipping off. We patch up the parts that we can on the surface, but all of our patches are doing nothing to fix the overall strength and foundation of the stone. And you want to do more, but you're stuck looking, and you keep doing your part to catch the pieces. But then there's a huge earthquake, like the 8.2 we remember in 1994. And that laddystone is now laying in pieces at our feet, and we can see deep into the center of the rock. This is where I find myself today. The Barragata Heights case and all of the allegations have broken open our program down to the fundamental processes, and now is our chance to rebuild it together. I know that sometimes you have to break something before you can fix it. Today, I come before you saying this is our chance to fix the program, revamp it, make it better, by establishing together a deliberate and intentional plan to move forward and give our people land finally. Man metgut hit na tautaugues zentadik tafamalik. We are a strong and resilient people. So before each of you senators, there is a compliance status report that was prepared for this meeting. I'd like to go over the contents of the compliance status report, which I hope will answer many of your questions and will also answer many of the questions that the public has about the program.
So, Madam Chair, before you go further, I just want to, what the senators up here have been provided is a copy of the compliance report. It's an 11-page compliance report listing basically additional areas identified for analysis and whatnot. But then there was also an attachment of about 150 pages of spreadsheets and whatnot. And after reviewing that, I decided not to print copies of that to be issued out because I felt that there was additional information that needed to be provided on that. And those additional information that I'm going to request, I will be going over that tonight. And I think there was about 6 or 7 different excerpts that I took out of that 150 pages, as well as you also provided this afternoon 80 pages of the resolutions that goes back to quite a ways back. That was 80 pages. So those I did forward. Actually, I forwarded even the 150 pages electronically to the committee members, but I felt that there's additional information that needs to be provided before I provide it to the entire legislative membership. So that being said, please go ahead then and proceed with your compliance status report.
Thank you, Senator. What I'll do is I'll just go through the report verbatim. So
You gave an 11-page status report. It was comprehensive. I think it merits you going through it as written.
Okay, thank you. This Chamorro Land Trust Commission Compliance Status Report was prepared by the CLTC Commission, Administrative Director, and staff. The report is intended to provide the legislature and public an overview of the issues that have been discussed at length in the media and at the last two CLTC Commission meetings on May 3rd and May 17th. This report also provides an update to the plan of action established at the last May 17th Commission meeting and provides additional information on the plan the CLTC has developed to move forward and address the concerns surrounding the CLTC. This report is just a starting point for a transparent and productive dialogue planned to commence today. The Commission hopes that their plans may be reviewed by the Honorable Legislature and made stronger together. The first section is the summary of findings and motions made at last week's May 17th CLTC Commission meeting. The regular CLTC meeting agenda's first item under old business was Lot 5382 North and Tract 9 Barragata Heights residential and agricultural leases to address the concerns and issues raised by the public in recent weeks. The agenda item was first discussed at the May 3rd, 2018 CLTC meeting, where the Commission was provided with a report from the Administrative Director on the leases issued at Barragata Heights and the timeline of events that led up to the leasing and clearing of an easement by the Department of Public Works. Since that May 3rd CLTC meeting, the Commission had worked towards getting a better understanding of what actions were taken and what issues needed to be addressed to resolve the concerns raised by the public. The Commissioners discussed the main concerns raised at Barragata Heights as follows. 1, the bypassing of applicants waiting in line to award leases to applicants further down the line, essentially not following the first-come, first-served mandate of Public Law 2338. 2, the impropriety of staff and management hooking up their family members. And 3, the clearing of trust easement without the appropriate clearances. The Commission then discussed and established a plan of action to investigate the concerns and allegations in order to resolve and correct each of them. Regarding the alleged bypassing of applicants waiting for leases for others later in line, the Commission decided to create a Barragata Heights bypass list, which would include all of those applicants without leases that are ahead of those applicants with Barragata Heights leases. The bypass list would be prepared with a report on why each applicant was bypassed. Client files would be reviewed and land agents would be interviewed. The findings of this report would determine if and where people were bypassed and where corrective action may be required. The second was to create an expanded bypass list for all 1995 applicants to see who is in the front of the line without leases and follow Public Law 2338, Section 5.10. To give some background information that was discussed, the last time the Commission created and published a bypass list for 1995 applicants was back in 2009. At that time, the list was published in the Pacific Daily News and instructed the applicants to contact the Commission and update their contact information so they may be awarded property. This was done in part in accordance with Public Law 2338, Section 5.10, applicant current information. However, back in 2009, the Commission did not follow through with the last step of the law, which states that, quote, "If the applicant does not furnish the information necessary to facilitate the award within 90 days of notice, the Commission shall remove the applicant from the award list, and the applicant must reapply as a new applicant." Because the Commission did not complete this last step, the current list of applicants the Commission is working with includes those that the Commission has had no way of contacting for at least the last 9 years. This means that those individuals on the current applicant list that should have been removed in 2009 remain. Regarding the impropriety of staff leasing property to their family members rather than following the first come, first served mandate of the law, the Commission decided that legal counsel will develop a policy and forms for the staff to declare if an applicant is related to them out to the 3rd degree of consanguinity. Staff declarations would be prepared and included in each applicant file. All CLT staff and management would be required to follow this policy. The Commission then moved on to discuss the Attorney General's opinion issued on May 11, 2018, and provided as Exhibit 1. The Attorney General opined that all residential and agricultural leases without Commission approval and countersignature are voidable. The Commission discussed the following findings. None of the residential or agricultural leases include a signature from the chairman of the Commission. The only signatures included in any of our leases are from the administrative director, the lessee, and sometimes the governor. A review of Commission meeting minutes dating back to when the CLTC first started issuing leases in January of 1997 revealed that there was no explicit discussion of reviewing or approving those leases. In fact, when the chairperson inquired whether the list of those ready for leases has to be approved by the board, the legal counsel informed the commissioners that the board doesn't have to act on it, noting the board had already set the priorities. Back at this time, the Commission was focused on reviewing every applicant's documents to verify the applicant's qualification as a native Chamorro under the Act. Review of Commission meetings between 1997 to 2018 did not include any regular agenda item or discussion related to the review and approval of residential or agricultural leases, even though leases were given out this entire time. Based on that discussion and the AG's opinion, the Commission moved that all future leases, along with applicants' files, shall be presented to the Commission for review and approval. All approved leases must have a signature block for the chairperson. The Commission then moved that in the future, when leases are awarded, the Commission shall follow Public Law 23-38, Section 5.9, Posting Lessee Awards, which requires that the Commission shall post in every municipal mayor's office and once in a publication of general circulation the names, file numbers, and dates of application of all who receive lease awards within 2 weeks after awards are made. They shall remain posted for a period of 60 days. The Commission then discussed the status of the 2,431 leases that have been issued in the program. The AG stated that those leases are voidable, which means they may be voided or the Commission can move to ratify them. The Commission decided to conduct an audit review on all leases. Discussion followed about how the audit would be conducted. Leases would be divided into piles. 1, Barragata Heights leases. 2, staff-related leases. 3, leases that have been transferred. 4, leases of applicants from 1996 to current. And 5, leases of 1995 applicants that do not fall in any of the above categories. Once those piles are created and upon review of the bypass list, the Commission may develop further steps to audit and review to determine whether to void or ratify the leases. The Commission then moved that no new leases would be approved without first completing the audit review in order to become fully aware that new leases have not bypassed anyone and the Commission is following the mandates of the law. The Commission then discussed the second part of the Attorney General's opinion, which stated that there is no authority that allows an applicant during his lifetime to transfer or switch places with another applicant. A lease in violation of this prohibition is null and void and is not subject to the Commission's power to correct or remedy. The Commission then discussed the following findings in regards to the switching of applicants' dates and times. 30 applicants from 1995 have been identified as having switched with an applicant who applied later. The first switch occurred in 2004 and was only approved by the administrative director at that time. There is no evidence that any of the switches, nor the administrative practice itself, was brought to the Commission for approval. Some of the switches approved by the administrative directors over this time were documented as having been approved for the following reasons: to prevent homelessness, physical ailments of the 1995 applicant. The 1995 applicant can't develop their property, but their family member is ready to build. The directors were trying to work with our applicants and get people on land without causing harm to anyone behind them in line by allowing the one-for-one switch. Of the 30 switches that had been approved, 17 of them include leases. The Commission declared that switching application rights in an applicant's lifetime will not be allowed moving forward or until the law is changed. Legislative remedy was discussed as an option that the CLTC may want to pursue in order to address the existing leases and switches. The Commission decided that more information must be gleaned on a case-by-case basis for each of these 30 switches in order for the Commission to take any further action or make recommendations. The Commission then went back to the issues raised regarding the clearing of the Barrigada Heights easement without the proper clearances. The Commission discussed the partnership between the Department of Public Works and the Chamorro Land Trust for the trading of services, surveys done by Land Management, clearing done by Public Works, as one that should be applauded. The government working together to share resources is a good practice. The issue the Commission had was that the Administrative Director did not bring the discussion with the Department of Public Works to the Commission for review and approval. The decision to clear Barrigada Heights was made at the administrative level. The Commission questioned whether there would have been another easement on CLTC property that could have been cleared instead to benefit a larger number of lessees. The environmental damage that may have occurred with the clearing happening without the proper environmental clearances was also of great concern to the Commission. The Commission then discussed the Barrigada Heights lease that the Administrative Director signed for his sister as her power of attorney and then approved and signed as the Administrative Director. The Administrative Director had expressed his disappointment with his actions for his sister's lease and lapse of judgment to me at a private meeting. I also discussed how I was in receipt of an email from Catherine Rita Blas Borja, Administrative Director's sister, which requested that her Barrigada Heights lease be canceled. The Commission moved to accept the lease cancellation of Ms. Borja. The Commission then moved that the Administrative Director recuse himself from all family-related CLTC matters. The Commission then discussed the finding that the Deputy Director for Land Management was deeply involved in the CLTC program, unbeknownst to the Commission. 21 switches of applicants' dates and times have occurred since 2015. 4 of those switches were approved by the current Administrative Director. 17 of those 21 switches were approved by the Deputy Director of Land Management. The Commission asked the Administrative Director if he was aware of the Deputy Director's involvement. The Administrative Director stated that yes, his Deputy Director carries out various duties across all of the programs that he manages as Director of Land Management. The Commission discussed the lack of transparency from the Administrative Director about the Deputy Director of Land Management's involvement with the CLTC. The Commission moved to remove from the CLTC any and all involvement by the Deputy Director of Land Management. I then called for a recess, and when the recess was over, the meeting continued with the regular meeting agenda. That was last Thursday, 1 week ago, and since that time, we have followed up and followed through with many of the motions and decisions made at that meeting, and today I will be sharing with you our updated plan of action. For the case of Barrigada Heights, The Attorney General has secured all Barrigada Heights leases and applicant files in their offices for review. The Attorney General's office will be conducting the investigation into the awarding of leases at Barrigada Heights. An investigator has been assigned to the case. Vice Chairman Mr. Joseph Cruz, along with CLTC Legal Counsel Nicholas Toft, will be interfacing with the investigator and will be reporting on the progress and findings when they are ready. No further actions by the CLTC on Barrigada Heights will be taken until the investigation has been completed. Report on switches. The CLTC has determined that the initial count of 30 switches between applicants' dates and times discussed at the May 17th meeting only includes those instances where 2 applicants switched places in line. A more thorough review has revealed that applicants have been allowed to relinquish their application rights to a family member. The exact number of instances that a living applicant had relinquished his application rights is not known at this time. A complete review of the 327 leases that have been categorized as transferred must be completed to determine if the transfer of a lease was the result of an applicant's passing or if the lease was transferred after the 7-year waiting period, both of which are allowed by Public Law 23-38. The review will also have to see if an applicant relinquished his application rights during his lifetime. According to the Attorney General's opinion, the transferring or relinquishing of application rights when the applicant is still living is prohibited. The Commission must flesh out each of these details on a case-by-case basis so that any decisions or recommendations on how to handle these switches or transfers in light of the AG's opinion is done fairly and with all information known. The report is currently being compiled and will be discussed at the June 21st Commission meeting. The bypass list. The Commission will be reviewing the list of 4,707 applicants from 1995 who have not yet received a lease. The Commission intends to follow Public Law 23-38, Section 5.10, to obtain current contact information for all applicants still waiting. However, the Commission may consider requesting legislative action to remove Public Law 23-38, Section 5.10's requirement that all applicants be served personally or be sent notice by registered mail. This requirement will be reviewed at the June 21st Commission meeting, along with an estimated cost to fulfill this requirement. The Commission may also consider implementing additional noticing methods that are more relevant to today, including but not limited to posting at every mayor's office or posting online. Streamlining the process to allow forms to be submitted online or via the mail may also be explored. The Commission may also consider if additional time to update contact information before removal of the applicant from the waiting list is warranted. Public Law 23-38 states that the applicant has 90 days to update their contact information. A review of the current process for the awarding of leases revealed an administrative policy that has been in effect for the last 2 to 3 years, which is, if an applicant comes in or contacts the CLTC and is a 1995 applicant, the land agent may entertain them and work with them towards obtaining a lease. This policy was derived out of the frustration and delays that land agents faced when trying to get in contact with the next applicant in line that was eligible for a lease. As discussed earlier, the list the land agents are working with is nearly 23 years old and contact information is outdated. To work around this, the land agents were instructed to document their attempts to telephone or otherwise contact the applicant, and letters requesting that the applicant contact the land agent were then supposed to be sent to the applicant's mailing address. If the mailed letter gets returned as undeliverable, the land agent inserts the unopened returned letter into the applicant's folder and can then move on to the next person on their list. This administrative policy to entertain all 1995 applicants to obtain leases had been discussed at Commission meetings. The general consensus of the Commission, Administrative Director, Legal Counsel, and staff was that this was a good policy. It was allowing the land agents to be more productive and issue leases at a faster rate than ever before. However, it is clear that this policy has failed on two levels. One, there was no oversight to ensure that land agents were following through with contacting and mailing each applicant waiting in line before moving on to the next eligible applicant. And two, no notice was provided to 1995 applicants that this policy was in effect. Now, the audit of all CLTC leases. The CLTC has compiled lists of the following categories of leases. 1995 applicant. There's 2,070 1995 applicants where they are the current lessee. There's 327 leases where the 1995 applicant transferred their lease. There are 16 leases of 1995 applicants who switched date and time. There is one applicant from 1996 or later who switched date and time and received a lease. And there are 564 leases for applicants that applied in 1996 or later. The Commission will be reviewing these leases and lists at the June 21st Commission meeting and determine what additional information is needed before moving on to ratify or conduct additional review of these leases. The listing in Exhibit 8 depicts 1996 and later applicants who have received leases, of which there are 564. Initial review of this listing finds that many of these were the result of leases passed on to the beneficiaries after the original lessee had passed away and the new lessee was required to complete an application. Likewise, some are for those persons found to be pre-occupiers of the land, whether through an LUP, a rendu, and the like, and have been justified by existing lists of those persons as well as by mayor certifications. A more in-depth review of this listing is underway and will be shared later. Additional initiatives the CLTC has identified to improve the program. 1, conduct a thorough review of Public Law 2338 for a comprehensive list of recommended changes. 2, to improve transparency, the CLTC will prepare staff reports for every public comment received. The monthly public comment staff reports will be presented to the Commission, covering the previous month's public comments. Staff reports will include the background and current status of the applicant that provided the comment, along with recommendations or next steps so that the applicant and Commission can review and resolve the issues raised. Next, we will conduct a review of the application processing and standard operating procedures. We will also conduct a review of how the CLTC absorbed authority over land use permits and the Arendu program, and how the CLTC can move forward to ensure equitable and fair treatment of those individuals considered pre-occupiers. We will also look at our staff workflow and processes, our standard operating procedures, and related forms. During this current period of no new leases being issued, the staff's workflow and processes will be examined to determine the best way the staff may be organized to execute current and future CLTC initiatives. We will conduct a program-wide analysis of the Tomorrow Land Trust land inventory to determine usability of the lands and their best use. This will inform the awarding of lots for residential or agricultural uses. We will also conduct a program-wide analysis of the necessary density of housing developments and the number of agricultural lots to provide land for all applicants. And finally, the Commission would like to appoint a full-time administrative director who manages the CLTC staff and exercises such powers and authority as may be delegated to him by the Commission. Next, we've prepared a schedule of proposed progress updates and future meetings. Progress update number 1 will happen at the June 21st Commission meeting. This Commission meeting will be chaired by Austin Duenas, with Chantel Teixeira and Amanda Santos in attendance. Items to be discussed include Barrigada Heights investigation results if available, switches report, bypass list, and the audit of leases. The July 19th Commission meeting has been canceled due to lack of quorum. Progress update number 2 will happen at the August 16th Commission meeting. All commission members are scheduled to be in attendance. This meeting will provide further discussion and updates for all initiatives contained in the updated plan of action found in the section above. In conclusion, the concerns and issues raised by the media and CLTC applicants over the leasing at Barrigada Heights initiated the Commission's hard look at the entire CLTC program. The Commission has determined that although real progress has been made in recent years, existing processes must be improved, the law must be followed, and greater transparency within and without the CLTC must be practiced. Existing laws will be examined, and recommendations for changes will be submitted to the legislature in order for the laws to be more reflective of the current state of the CLTC program. The Commission understands that it will take time to make all of the improvements necessary for the CLTC to function in the way it was intended, and the Commission is optimistic that real change and progress toward fulfilling the mission of the Chamorro Land Trust is attainable. The Commission looks forward to the input and support of the senators of the 34th Legislature. Thank you.
Thank you very much, Ms. Farron. Before I open up to the panel, I do want to point out certain things on the attachments, on the exhibits that you provided, and what I believe are questions, additional information that needs to be provided to those exhibits, I think, to give it its full information value. So the staff, can you pass out the exhibits? Do they have it already? They've been passed out? Okay, so each senator, then you will see a sheet. It says at the top, Exhibit 2. Do you have a copy of that? Okay. You have a copy of the exhibit? Okay.
Yes.
So on that particular exhibit, I would ask that the same information be provided, but with the additional information as requested. One is the application date of the transferor, and 2, the application date of the transferee. So I want to see whether is a 2016 applicant switching with a 1995. So I need the application dates of the transferor, the application date of the transferee, and the relationship of the approving official and transferring parties. Okay?
Okay.
On Exhibit 3, the title of that exhibit is CLTC applicant transferred their leases. So with that, if you could add additional information that shows that the transfer was made pursuant to which rule. It could either have been made under Rule 5.8, 6.4, 7.5, or 9.1. But by providing that information, we would then kind of get a quick look at what was the basis or what was the authority for that was invoked for that transfer. And again, the relationship between the transfer and the transferee. So right now, the rule says that there's one rule that says that after 7 years, the lessee can transfer to any individual. In another rule, it says that Upon death, it can be succeeded only by a defined beneficiary who's familial. So if you could provide that additional information then as to the relationship between the transferor and transferee, and also the approving official. Was it the director, the commission? Okay. On Exhibit 4, it's titled 1995 CLTC Applicants Bypass. If you could provide 3 additional information for that exhibit. One is the reason for the bypass. Outdated information, cannot contact, whatever. The other information is the official who approved the bypass. And thirdly, the priority category of the applicant that was bypassed. In fact, does the CLTC, is it in the rules and regulations, there's 3 criteria for issuance of awards. 1 is a qualified chamorro. 2 is must be 18 years or older. And then there's a category that's been set up. Priority 1, those with no land. Priority 2, those with, I believe, 1 acre or less anywhere, Guam or the U.S. And priority 3 is to those with 1 acre or more anywhere. So I would like to see basically the priorities that these applicants have been categorized in. And then there's Exhibit 5. Exhibit 5, the title is 1995 Applicants Original Lessee. And on that one, if you could provide with that the priority category of the applicant. And finally, there's Exhibit 8, which are the CLTC 1996 and later leases. But on that one, I'm seeing, as you can see, I've pointed out 2 particular entries. But if you could provide a separate listing.
I'm sorry, we don't have a copy of that one? Exhibit 8 or?
Exhibit 8.
Oh. Sorry, found it.
CLTC 1996 and later leases. So if you could provide from your database, provide a separate listing of pre-occupiers pursuant to Rule 6.4. 6.4, it says that you will not evict those who are on public land already under the Arrendo program or some other land use permit. But we want to take a look at that. And to that one, the question that I have is, do pre-occupiers go to the front of the line? And I asked that question because as I was going through the exhibits, I saw that there was one applicant who applied in August of 2012, got a lease in December of 2012, and on the remarks section is that he was a pre-occupier since 1980s. So that begs the question of, do pre-occupiers go to the front of the line? So the program started application started in 1995. This individual applied in 2012 and within months was able to get a lease. Finally, what was provided, and I believe it was 80 pages, that information that you provided was the list of all the resolutions that was passed by the Chamorro Land Trust Commission. And I made a copy of resolution number 2013-01. It's a resolution to clarify the power and authority of the administrative director relative to the negotiation of purchase or lease of buildings, materials, equipment, and services. And I point out this particular resolution because in the third whereas, it states, whereas pursuant to Public Law 2338, Sections 3.1 and 3.2, the Administrative Director is given the authority to authenticate and sign on behalf of the Commission licenses, leases, loan contracts, personnel actions, procurement and purchase forms, contracts with other governmental agencies and Commission resolutions, and having full charge of and responsibility for the administration and execution of all actions approved by the Commission and in effectuating the Commission policy. But what's noteworthy is that with that particular rule, it is very clear that in Rule 3.1, it says very clearly, after approval of the Commission, the Director shall sign. In Rule 3.2, it says the Director shall have full charge of and responsibility for the administration and execution of all actions approved by the Commission. So it is made very clear in the rules, and the resolution doesn't seem to clearly reflect that. So I would certainly suggest that the Commission pull back that Resolution 2013 and make further clarifications to it so that it clearly reflects Rules 3.1 and 3.2. Okay, so with that, I'm going to go ahead and open up to the panel for questions. Speaker Cruz.
Let me start with that last issue about the signature of the Administrative Director without the Commission's approval. Mr. Borja, I wonder if you can recall a hearing that we had at the old building where I admonished you that the power lay with the chairman of the Commission, and that you may have been previously the chairman of the Chamorro Land Trust Commission, but as the new director of Department of Land Management, the power over the Commission did not come with you. And I tried to remind you that you couldn't do this, and I now see that my admonition was ignored. Do you recall that?
I do recall, Speaker, but if you would look at the listing of all the resolutions that were provided, the bulk of them were provided under my watch as an administrative director to ensure that any of the actions that we did that required me to take action on had the approval of the commissioners. So I did take that seriously to understand that that's what my responsibility was. And when there were actions that were required out of my bounds, I did get Commission approval for those types of things, and I moved to make it happen either by a motion at the meetings, or definitely for the more serious ones as resolutions.
I thought in the report that was provided there was a statement of a number of the leases that were signed only by the Administrative Director and not signed by the Chairman of the Commission.
And as she also reported, that all the leases dating back from the inception were all signed by the Administrative Directors and not the Chairman.
Because I was schooled in the Chamorro Land Trust by the Vice Speaker 23 years ago. And I had always thought that the chairman and the commission were the penultimate power, and I didn't realize that there was any abdication of the power either by resolution or by any other means, because it was intended the way at least I remember being told what the Chamorro Land Trust law was supposed to read, that the commission and its chairman were the penultimate power as it relates to leases. Of the 2,400 leases, on the Attorney General's opinion, how many leases are avoidable because of,
From our review, because they did not have the chairperson, none of them had a chairperson's signature, we're viewing all of them as voidable.
all the leases are voidable?
And we do not have record of the chairperson approving and then moving to let the administrative director sign for them.
So there's no resolution that says these 10 at this meeting that we've approved can be
Correct.
signed by?
Correct.
Thank you.
Senator Nelson? Senator Reagan?
Thank you very much, Mr. Chairman. And Mr. Chairman, I just want to say thank you for requesting all of the information that has been presented this evening. And to the members of the commission, thank you for forwarding the information to the committee, because it's very informative. And I'm glad to hear that there's a recognition that certain things have to take place in terms of looking at the process, in terms of looking at personnel, and perhaps some additional training, and start off with looking at Public Law 23-38 and just recognizing every single section that says first come, first serve. I know you mentioned that on the month of December that there was a decision that recognized that the month of December can be isolated. I really differ with that process. And the reason being is you provided a list of names, and this is only a singular page, mind you, of CLTC applicants bypassed in 1995. This is just one list. And the submission was on December 2nd. This is Exhibit 4, Mr. Chairman. December 2nd, which was the first date in which the Chamorro Land Trust Commission started receiving applications. The time of the first individual on that list is 8:07 a.m. The time of the individual at the bottom of that list, and mind you, it's an extensive list, probably in excess of 25, 30 names, if not more. The time frame of the submission and the acceptance of the application for the person at the bottom of that list is 9:07 a.m. So that tells me that there are just so many issues that has to be addressed with regards to the process. And Mr. Chairman, I guess the one question that I have is looking at page 9 of your presentation, the audit of the CLTC list. You have 2,070 leases that have been given out. 1995 applicant is the current lessee, 2,070. And then let me just, if I may, Mr. Chairman, just highlight these. 1995 applicant transferred their lease, 327. 1995 applicant switched date and time leases, 16 in that category. 1995 and later applicant switched date and time, 1 person. And then 1996 and later applicants with leases. And perhaps, let me just pre-qualify this, because perhaps some of these may have been actual transfers. But it says, just looking at this on the surface, 564 individuals, 1996 and later, were given residential leases, of which you also highlighted in your presentation that there are still 4,707 applicants that have not been entertained in 1995. So just for the information of everyone here, that tells me if I take the 2,070 leases that have been given out, the 4,707 leases or applicants that have not been entertained with land leases, it tells me that just in 1995, between December 2nd and December 31st, there were approximately 6,777 applications received by the Chamorro Trust. And to look and to see that 1996 and later, there were 564 leases given, while we still have 4,707 applicants waiting in 1995. That's where some of these issues come up. It has to be addressed. And Madam Chair, you mentioned that these are some of the situations that you will be looking into. And I certainly hope that this will be expedited. And I would encourage you and the commission members to reconsider that identifying December 1995 as a block, because the law says first come, first served. So in other words, that exhibit I just shared with you, the individual that submitted the application at 8:07 a.m., who was bypassed, 8:07 a.m. on the 2nd of December, should really be the next person in line to receive a land lease, inclusive of all the others, according to first come, first serve, not the month of December. And that's where I know that the process was previously shared with me by the executive director as to how it was worked out, but there's nothing that prohibits all of the team members, the land agents that are giving out properties, that have identified properties, and sit on the same table and say, okay, these properties are available for distribution, who's next on that list?
Okay, Senator, if we can allow them to respond.
I encourage you to reconsider that particular process, because right now we still have 4,707 applicants that are waiting for land leases in 1995. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you.
Thank you. Before I move on to the next panelist, is the Commission using the priority categorization such that, for example, on this bypass list, might it be possible that the individual that applied at 8:07 a.m. May have been bypassed by somebody who applied 2 hours later, because the later applicant was a priority 1 applicant? So is the priority categorization being used as required by the law? Do you know?
When it comes to the ownership of lands, those are the kinds of questions that we ask on the interview when we're going to assign a lease, to find out where they're at. But I'd like to just note too that if that 2009 published list had been fully taken to its extent to remove that exhaustively long 16-page document of all those applicants who didn't come forward to update their records, we probably would have a much smaller list to deal with in December 1995. And because it wasn't, we're going through those same people that were once listed but not removed. We do this, and we follow it through, it could lead to quite a few people being removed again, and that's why an individual perhaps in the December 2 at 8:07 a.m. may still be there. Now, I can't say for certain that that's the case of that specific individual.
All right, thank you. Vice Speaker?
Thank you. I want to thank the Commission members. I know I see many of you here. Thank you for being here. Thank you for this very detailed accounting to date of the information that you've been able to uncover. This is the methodical and detailed and systematic approach that I think the public deserves, and for me personally, very, very helpful. I mean, this will answer all my questions, especially if you add the information that the chairperson has requested on these spreadsheets, because then all our questions will be answered and we can start to really come up with closer to, what do we do about it. But we do need information. So this is like gold right now, this information. I did have a couple of questions. So I think these lists, they provide transparency. They are your Bible to get us to fairness, right? This listing, this spreadsheet. My question is when one of these tables says, first of all, the applicant's bypass list, it's Exhibit 4. It seems like it's just got to be too short. Because where's the rest of the month of December? Are you saying no one else in December was bypassed?
No, ma'am. If you look at what...
Well, please note that I believe on the exhibit, what I took out was just an excerpt.
Okay.
But I believe like the bypass list was probably what?
79 pages.
That's what I wanted to know. Okay, that makes much more sense. Okay, then. Perfect.
And I just want to note, Madam Vice Speaker, that, the hard work of our staff in assembling this list wasn't done overnight. This has been an ongoing process from the onset of the program, and it's still a very active and lively program. When we come across certain other things that we decide we need to highlight and add another column, another field, we do that. And it's a very protected list within the COTC to ensure that there's no tampering to it. It's a read-only file. Okay. There's only one trusted person to make all the entries. And that person has been with us from the onset of this program and has been keeping these. That's the reason why we have been able to provide you with very detailed lists, because we're able to sort them in different ways for you.
All right, then thank you to your staff and over all these years for these lists. This is very helpful, and it's a great policy that it's protected. Okay, so then my only issue for right now under this round robin, we're doing Exhibit 8. Could you please add on to this, now these are those who have received leases 1996 and later, who applied 1996 and later, and I think this will also include the land use program, the Arendu, and so I want a category that shows pursuant to what proof, what justification. Did you get a list of the Arendu people from the department, or did you get a list of land use applicants, or were they on mayor's certification? Because I've seen some of those, and I really want there to be a separate list for those.
If I could just comment on that, before they began this program, the Department of Land Management actually went out and through the Arendu program, the land use permit program, and the Department of Agriculture lease program, assembled a list, and today we still use that old database printout of what we used to validate who was what and what their LUP number was that was assigned to them. Otherwise, for preoccupiers, we have to depend, because they have no other source of documentation placing them on that land, we have to resort to the mayor's certification that they had been there prior to 1994, so that we can, and that's the documentation, but we'll go ahead and try and
that would be helpful, because those are the ones, if they're on a land use and a Arendu list, then I don't have questions about those. I do have questions about the others that I'd like to confirm.
But I would like to note that on this Exhibit 8, it's 15 pages long. Oh. 13 and a half pages of that were people who got leases for whatever reason before 2011.
What do you mean?
And this was the reason the 2009 list that had to be published was ordered to be done, because of the jumping that had occurred, not just within December of 1995, but well outside of that list, well beyond that.
Are you saying that there are people on this list then that are not going to be qualified under the Arendu or the Arendu program?
Correct.
Okay. Yeah, well, that's not apparent at all on this list then. And I didn't even know there were more pages. Okay.
Yes.
I guess I'm understanding.
On the bottom of all these exhibits, I actually put down the total number of pages.
Oh, okay.
So you can get a grasp of how large these lists are.
For this one, for sure, then. This is the jump list, right? And these are the the later applicants. So please, we're going to need some more columns.
But this was the cause
Yes.
for the 2009 publication.
All right. All right. Thank you. Thank you, Mr. Chair.
Thank you very much, Madam Vice Speaker. Senator Lee?
Thank you, Mr. Chair, and thank you all so much for being here. I also want to expand on the sentiments that the Vice Speaker just shared, and thank you to the board and to the staff for really taking the time to provide us with this very thorough report. I also agree with what the chairwoman has said about this being an opportunity for us to review the program as a whole, to take a look at our standard operating procedures that may or may not be in place, and to ensure that going forward, this program has the integrity that the public deserves. One of the questions that I had as we were reviewing the report, on page 10, you were discussing, you discussed a number of initiatives, but on page 10, you listed additional initiatives that the CLTC has identified to improve the program. And so my question to you is, if you could please provide the committee with some concrete numbers and the overall costs of some of these items. So, how much it would cost to conduct this review, how much it would cost to have maybe the staff be trained in additional workflow and processing, how much it would cost for the program-wide analysis of the land inventory, and if you are considering an additional cost for the full-time administrative director to manage the CLTC staff and exercise the powers and the authority that might be delegated to this person by the commission. So if you could get back to us with that, that would be extremely helpful, especially as we're going through our budget process right now. So I want to thank you in advance for that.
Thank you, Senator. We're going to go ahead and start with our round two. I'll start. First of all, I know that you've required of the staff to basically sign some kind of affidavit indicating to what degree of consanguinity are they related to the lessee, and that is to be put in the folder. I would like to ask that you consider that each land agent and each employee of the land trust be required to read Public Law 23-38, which is the rules and regulations of how we process the applications, what's allowed and what is not allowed. And one would think that because the individual has been working in the commission for the longest time, that he knows all that like the back of his hand. We found that to be not the case, for example, in the case of procurement. We've had many procurement people who have been working, and they really weren't familiar with procurement, the procurement law. So I would ask that be required, and if you could, maybe within the next 30 days, that is something that they should do.
Sir, if I may respond quickly.
Yes, please.
Since May 17th's meeting, where we decided all the CLTC staff would do those staff declarations, we've discussed, and we will put it forth at the next meeting, that we will expand that staff declaration to be all Department of Land Management employees, including commission members. So all of us will be making those staff declarations. And to your point about training, yes, I failed to include that in our initiatives. And Vice Chairman Joe Cruz has been a huge proponent to get all of our staff trained up, just to sit down at the very basic to read the law. So we will be sure to make that happen.
Okay. And truth be known, I get training too in my office. My chief of staff reads the thing, he knows this thing backwards and forwards, and he sits us down along with the staff to let us understand that. I wasn't clear, did you say that priority categories are being used, or did we, or as the commission set that aside? That is actually the third criteria.
Right. It is given consideration, but it could probably be stronger.
Okay, so possibly a priority 3 applicant might get a lease over a priority 1.
Right. Well, one of the issues here is the ownership of land. And, you know, it's not, we can verify that, but it is most definitely one of the things that I've kind of wondered about, you know, because I do see landed people, well-landed people taking advantage of the program as well.
Okay. And the final question that I have for this round is regarding the Barrigada Heights clearing. Now, I actually took a drive up there, and I'm sure that there's a couple of landowners that are at the top of the road there that probably have some real concerns, because when the road was cut, the slope seemed probably a lot steeper than normally, and you can already see the erosion starting to take place. So I don't know, has an engineer been up there to review that?
I know what you're talking about. It's private landowners that were encroaching well within the Chamorro Land Trust property to put their backfill without any kind of retaining walls. And when the folks that were excavating and moving opening up the easement noticed that, they definitely went around it. If they had gone through it, they would have caved in their whole backyard, because they had used other properties, not their own, to hold up their own without building walls. And it doesn't take much to even look at an aerial to notice as well that many of the other private property owners had encroached into the land trust properties to expand their yards.
Okay.
But they definitely knew where their property was, because the fence line showed it as well.
All right, thank you very much. Speaker Cruz?
I thank you for putting at the bottom the number of pages and where this came from, because I think it's important, and I'm hoping the chairman will post these online. For the bypass list, there were 79 pages of people that were bypassed. And how many people are on each page? It's at least 40. So there were a good 3,000 people that were bypassed. And then the pages for the ones who applied after 1996 who got leases, there are 15 pages of them and about 40 per page. So these were 600 people that leapfrogged over other people. Am I in the
And as I
correct
mentioned, Mr.
neighborhood?
Speaker, yes, you're correct. But the vast 13.5 pages of that 15-page document were people that were jumped well before 2011, but it was the result of the 2009 publications list, because of those super jumps that had occurred during a time period prior to 2009. And that's the result of that list. That's the reason that publication list came out, to show who got bypassed in the whole program. And as I mentioned earlier, if they had taken the next step after that publication list to remove the non-respondents, then our overall list, and especially most likely the December list, could probably be vastly smaller.
And what other measures were taken to notify these people that didn't respond when you made that publication?
Well, there's multiple steps in that notification process. It's you shall publish, and you shall either serve or send a registered mail to them. Now, if we had to go through this process, and as the Madam Chairwoman had mentioned, trying to find alternatives to that through legislation, If we had sent out a registered mail to 3,000 people at $11.90 a letter, we're talking $36,000 just to do that. And that's, you know, really way out of our budget. We need to discuss the notification process, bring it to, as was mentioned in the document in this report, to more modern times of notices online or other ways to give that notification, or perhaps to even do it as a certified letter, which is only $3.60 a copy. And that brings it down even smaller, but it's still quite a lot. And so that's the kind of thing we need to look at. The reason for serving a person is understandable when you're trying to register a piece of property, because you must notify an individual who is a fee simple owner of a property or has interest in a property. But what you're asking us to do is to give that same kind of notification process to an individual who has no interest whatsoever except for the fact that they are an applicant. And that seems to be a little bit extraordinary in this process. And so we have to look at that. I think that perhaps might have been the cause, too, that they did not complete the other shall be done things in the law, publication and either process server or registered mail. So that may be the cause. But that, for us moving forward, if we still must comply with that, we'll never delete anyone off the list if we can't afford to even send out registered mail. And that's just way too expensive.
How many leases have been signed, total leases from 1995 to the present, so the general public can have an understanding? How many leases have been signed, and how many people applied, so that we know what percentage of applicants have actually received? Does anybody have that number currently?
I know that in the 33rd legislature we had actually done an oversight hearing. I don't know if we have but we did take account of the total number of applications. I think that's on the database is about 12,000. As of about 2 years ago, there was about 8,000 still pending.
Yes.
So about 4,000 have been awarded.
Under 4.
Under 4.
I don't have the number off the top of my head.
So we're about fourth.
Third of the way.
A third of the way.
Less than
Fourth.
25%, yeah.
Third.
Yeah. Okay. All right. Okay, but there's out of a total of 12,000.
The number of leases, at least from the table we've prepared, is 2,978 leases. And I don't have the exact number of total applicants, but if we're estimating at around 12,000, we're at a 25% leased rate.
Right. Okay, Senator Nelson.
Thank you, Mr. Chair. I have several questions. In your testimony, Madam Chair, you stated the Attorney General opined that all residential and agricultural leases without commission approval and counter-signature are voidable. So really alludes to that what you stated, none of the residential or agricultural leases include a signature from the chairman of the commission. And a resolution forward is that you're looking at future leases with the applicant shall be presented to the commission for review and approval. Is there any requirement for you to address the previous leases from this time back?
So that would be why we would do an audit of all the leases to see where we are, where those leases stand.
And what would be the determining factor? Do you have perhaps maybe selection criteria for the audit, or decision factors, points of decisions where either you would determine the leases are voidable?
We haven't gotten there yet. We're first trying to get a handle on what's out there and what we have.
Okay. And then,
If I may, I guess to the question of what is the criteria, it's really Rule 5.2, qualification of applicants. So you got to be Chamorro, you got to be 18 years of age, and then those applications are categorized as priority 1, 2, or 3.
I guess that's how you're going to do it then. So this will also be thank you, Mr. Chair. This will also be addressing the switches of the leases. So, the switches that are null and void, you would also consider that in the audit and the requirements of that section 5.2 that the chair pointed out, right? Okay, and then I do have a question. In your testimony, you stated that this is in page 7, that the Commission discussed, the second to the last paragraph, the Commission discussed the lack of transparency from the Administrative Director about the Deputy Director of Land Management's involvement with the CLTC. The Commission moved to remove from the CLTC any and all involvement by the Deputy Director of Land Management. This is very vague, no, the way you say lack of transparency. Can you explain a little bit about this lack of transparency that you saw, or the Commission saw, something more concrete, to give an example?
Yes. So I've sat on the Commission for 2 years, and I've had multiple meetings with the Director, multiple meetings with his supervisors and the staff, and we've had the many Commission meetings, and not once in any of those meetings was the Deputy Director brought in to discuss any of the work that he had been doing within the program.
Can you mention anything specific that caused you to just... what I'm getting at here is if this individual abused his authority as the Deputy Director, perhaps what are some of the consequences that he'll have to face? No, this is very important. And so, is there something concrete? Is this, where are we at with this?
From the discussion that we had at the last Commission meeting with the Director and asking him what role his Deputy Director plays, he described that the more administrative duties within the CLTC program were handled by his Deputy Director, as a Deputy Director does, as the Deputy Director does for his other programs and other agencies where there are Deputy Directors. The main Director passes on some of those authorities, and it's also become more clear what the Deputy Director's role was, and it was those administrative duties. So he was not signing leases. He would be the one that was looking at the transfers and approving them. He was looking at utility authorization requests, survey authorization requests, and there's a whole list that I was provided as to the Deputy Director's role in the CLTC program.
But if I may add, this Deputy Director was also serving as the Acting Director of Land Management and the Acting Administrative Director of the Chamorro Land Trust Commission for a long period of time during the absence of the Director for terminal illnesses. And so he has served in that role. He additionally has served very well in being the ombudsman of sort, in talking specifically, mainly with a lot of the elderly applicants, but with any constituent complaints that we get, he also assists with those matters. And he does work in ensuring that the productivity of the staff is kept at the highest level. So he did have an intimate role in that respect.
Thank you, Mr. Borja. Thank you. And before, Mr. Chair, just real quick before I close, I understand that he's done a lot, but this is a very grave decision to say, because he's been the acting director many times, to really say that they're removing him from all involvement of the CLTC. So I'm kind of thinking that something else happened that we're not seeing, and this is just the surface. And some of the responses that I received are kind of fluff responses, but perhaps we need to delve a little deeper into why this decision was made. Thank you, Mr. Chair.
Thank you very much, Senator. Senator Ruggan?
Thank you very much, Mr. Chairman. You know, just looking at the overall process and some of the testimony that's provided today certainly bodes well in terms of pushing for fairness and transparency, and that should really be at the forefront of this entire process. But I have a question with regards on page 5 with the Attorney General's opinion. The Commission then discussed the second part of the Attorney General's opinion, which stated that there is no authority that allows an applicant during his lifetime to transfer or switch places with another applicant. And we're referencing individuals that are alive, okay? A lease in violation of this prohibition is now and void and is not subject to the Commission's power to correct or remedy. So just based on the AG's opinion, the first course of action should have been immediate notification to all of these individuals who have been given leases under this process. And I haven't seen that in terms of an action by the decision, because the AG's opinion is very clear. It's now and void and is not subject to the Commission's power to correct or remedy. So can I ask for a response on that particular question, please?
Yes, sir. So the Commission felt that before we can get to that point of noticing the lessee or making any decision whether their lease was null and void, is we first had to check which leases are affected by this opinion. We thought it was just 30 initially, but we did more homework and we realized that there may be a lot more out there. So we have a list of, I believe it's 327 leases that are categorized as transferred. Now, some of those transfers may have been done in accordance with the law. The transfer when the lessee dies, that's one transfer. The other transfer is if the lessee had waited the 7 years and done the transfer. But then also there were instances that which is why we have to review all 327 instances where the lessee or the applicant relinquished their rights to their place in line, transferred it to another individual while they were still living.
Okay, I understand about doing the necessary research and certainly doing due diligence. It's just that I would recommend that because the AG already opined right after the completion of the research, there's really no remedy on the part of the Commission. So these individuals and these family members need to be properly notified if in fact there was not a proper and a legal transfer of or switching of land leases. Thank you very much, Mr. Chairman.
If I may add, sir, the process we're looking into is to also determine if they're inhabiting, and if they're inhabiting, what kind of home is there? They're living there. I think what we want to try to avoid as well is to displace people from their homes. Now, the Attorney General did say that there is no power for the Commission to take on this, and that's why we want to look in depth into what's here, and ultimately make a recommendation to the House that can make the decision, and hopefully come to the legislature with a solution to then authorize some of these, especially for those who have homes and that's their domicile. And so that's what we're looking at, but to give them eviction notices. But yes, understand, to give them notice that there could be a consideration. We don't want to put a panic out there right now, although we do want to look and get more details. So we have inspected many of these properties and have done assessments to determine what's there and whether it's occupied and what kind of structure is there and such. So we're going through that process already.
But just, if I may, Mr. Chairman, just to close out on this particular question, I noticed that most of the transfers or the land switches have taken place since 2015. So in that particular situation, I would anticipate that there has not been possibly too much investment in terms of the use of the property. And yes, a remedy could be sought, but what about all the others? I mean, just looking at the first date of first month of December, the other 4,707. That's where the fairness and the equitable treatment of all the applicants comes in. So it really has to be with either we're fair with the process, we're open, we're transparent, and we distribute the land leases equitably based on the law which says first come, first served. So I'll leave it at that. Thank you, Mr. Chairman.
Thank you very much, Senator. Vice Speaker?
Thank you. I think the process that you've outlined will hopefully put before you and the commissioners those leases that really we have no questions about, or you have no questions about, and that perhaps the commissioners could act in accordance with law and either approve or approve, right? Perhaps. All the others that have any type of question, I hope that you will, set those to the side, and let's give some confidence to the ones with absolutely no questions. But all those others, yes, I think I'm just, of course, this is an immediate reaction, and we're open to your recommendations. But yeah, it does not feel good or sound right that we are going to be approving things that were done totally contrary to the law. I'm not looking forward to that. I've seen too many bills come through here where we're trying to make exceptions to existing laws. And then all the other people who had to comply with the law, I think, are treated unfairly in that process. So, but I just wanted to point out something in the law also, just to bear in mind. Now, I know, Mike, that you were the former chairperson of the board and then became the director of land management eventually. And it was like, I think by executive order, that the director of land management then became the director of, or the administrator of this Chamorro Land Trust, together. And I know that even before I was senator, I kept raising concerns about that because it's my reading of the law, and I'm just going to read it to you now, just so that going forward, and I see you have a proposal for an administrator, and but yes, it says, 75106, the powers and duties of the governor and the department, meaning the Department of Land Management, with respect to lands of the territory, shall not extend to lands having the status of Chamorro homelands, except as specifically provided for in this chapter. And just, something to bear in mind also when you're going forward, but it looks like you may have already been thinking about that, and no fault of yours, Mike, in this appointment, but I just always think that there was a reason why this law was crafted this way. The longer I've looked at this law, the more I've seen that it really had a lot of wisdom and vision behind it, and I don't like to tinker with it. I think we should try our best to honor the intentions of it, and we'll see where that goes. But thank you again. Thank you, Mr.
Thank you, Vice Speaker. Senator Lee?
Yes, thank you, Mr. Chair. Also, in the spirit of fairness and transparency, Madam Chair, you were speaking about on page 9 of your report that the Commission may also consider implementing additional noticing methods that are more relevant to today, some including but not limited to maybe posting at mayor's offices or posting online. And so I did a quick Google search of the Chamorro Land Trust, and one of the only things that came up was an Office of Public Accountability report from fiscal year 2014. And so, is there a Chamorro Land Trust website, or is there some other kind of website with information, contact information, and how people can get a hold of you folks?
Yes, the Chamorro Land Trust does have a website. I believe it's a page on the main DLM, Department of Land Management website, but we do have our own section where you can find meeting minutes, past agenda items, information about the commissioners, and so on.
Okay, you also noted that streamlining the process to allow forms to be submitted online may also be explored, and so that's definitely something that I think that we should take a look at doing. In addition, if we don't already have this on your website, perhaps maybe like a frequently asked questions page. I think in the discussion that we've been having in our community, and that, you know, with the media reporting on a lot of these things, with the Chamorro Land Trust, I think some members of our community are conflating Land for the Landless programs and Chamorro Land Trust, the program as a whole. And so I think it would be a good opportunity for us as a community to kind of have a conversation about the differences between those programs, and just get a better understanding of CLTC, its history, and maybe answer some of those questions up front. Thank you.
Thank you very much, Senator. I will go ahead and we'll start with round 3. First of all, I'm glad to see that you've actually planned out how you're going to proceed forward and address some of the concerns, and I'm happy to see that you've put timelines as to certain things taking place. And I realize that, well, I guess you're going to get a progress update on June 21st, August 16th, but I would hope that at some point I would be looking at around possibly as early as September, before the end of this fiscal year, to be able to get those recommendations for updating the rules and regulations, our 23-year-old rules and regulations, because a lot of things have happened over 20 years. And so we need to update that. And if it requires legislative intervention, that process could take a little bit of time. It's not going to be just one public hearing when we propose these changes. So we're going to need, the legislature is going to need some lead time also. I'm happy to see that, you know, this is not going to stretch out for the next administration to finish. I want to see that that we get this thing at least tightened up and move one step forward before the end of this year. I want to raise the concern that I have, again, going back to Barrigada Heights. 2 things. First of all, I noticed that what was published in the paper was that there were some residential leases that were issued. There was also agricultural leases that were issued in the same area. So I'm just wondering, is Barrigada Heights, I mean, is that what we're doing? It's kind of like, I want an agricultural lot there, and then the other guy says, I want a residential. So now we got an agricultural and a residential lot side by side. Is that what's happening there?
Barrigada Heights, the original lot number for that encompassed the whole hill. And so in the early days, there are some agricultural lots on the east side of the hill that had been issued out a number of years ago, and they're being used in that, in an agricultural way. There's trees all over the place back there. There were some in this one particular tract where the clearing was at. There were a couple of lots that were given notice of intent to award many years back for agricultural lots as well. And so those were the ones that we had to continue to preserve. But yes, we try to make sure that we segregate those 2 kinds of activities. And so what we have done in all the other parts around there is then subdivide them down into half-acre lots for residential purposes.
Okay. The other concern that I have, which was brought out by the Barrigada Heights clearing, is the use of general fund resources on Chamorro Land Trust property. So the equipment that was used, and inasmuch as I want to see access easements into the Chamorro Land Trust property accomplished, that work effort should be paid for with Chamorro Land Trust revenue. Yet we take the bulldozer and the manpower to clear that road, and those resources are funded by the general fund, which is paid by taxes from everyone, even those who are not eligible for Chamorro Land Trust property. So it's asking for trouble if we continue that practice. And I applaud you for saying that it's a good example of government agencies working with each other, but it doesn't work in this case, I don't think. If you care to comment on that.
Well, the Department of Land Management Survey Division has been cooperating directly with the Department of Public Works in the surveying of easements around the island and doing centerline wherever there needed to be roadway improvements in general areas, and the activities that they've been doing. And so that's the collaboration between the two departments, where they have asked for our services, because we're the only surveyors in the government, to just provide that center line so we can ensure whether it's a roadway that's going to be cleared, that it's always on an easement, or a bus stop that's going to be placed, that it's also only on an easement. And in this case, the exchange of services was when your equipment is not being used for anything else, could you please assist us with opening easements? But that's the extent.
I would caution the land trust about using general funded resources to do work on Chamorro homelands.
If I may, Senator, I agree we need to confine CLTC activities to CLTC money.
All right, thank you. Now, I've gotten a lot of emails in my office asking for where can they look at a list of where they are on the list of pending applications. I really don't want to put that on my website. I would rather that it comes from one source. So will the Land Trust be putting up on its website a list where somebody can go in and say, well, I'm number 2000 and whatever?
There is a list on our website.
There is?
Yes, sir.
And what is that website address?
It's in the CLTC website that's within the DLM web page, but
Okay.
it is there.
All right, we'll look at that. And that is updated as of what? As of when?
I think April 28th.
April 28th of
2018.
18. Okay, great. Thank you. I think it was last year there was legislation that was introduced to recover land for the landless lots that were defaulted. I believe there was about 400 of them. And I think as a result of that law, I think what you recouped about 300 some lots, which then goes back to the Chamorro Land Trust. These are lots that were in areas that already had, for the most part, infrastructure. What was what has been done with those properties?
Those properties are still within the Government of Guam inventory. We are working with legal counsel to determine how the proper administrative transfer will take place. There are approximately 230 lots where there's been no response from the original individuals who were given the contract to deed, or they've completely defaulted and not responded at all. But we do have individuals that have taken part of the two public laws to extend that program and give them that opportunity to pay pay for the land. We've already been issuing out deeds for those people who have fully paid for those lands. There are a few that are on the contract to pay for the next 2 years, so they're not included on that list. Nor are several. There's probably a dozen of them that are on that list where, again, no response, or they were inactive in coming forth and doing anything more, but they're living there. there is actually a home on that property. And so those, as I mentioned before during the whole Land for the Landless hearings, we need to look at those people and figure out a different way to deal with them, because otherwise we'd be displacing people who are living on homes. And some of those homes are in the Saguenay-Lauzon area.
How much longer is closure before closure is brought to those lots?
The changeover?
Yeah.
It shouldn't be much longer. Again, legal counsel is just coming up with the wording to be able to do this.
Okay, great. Thank you. Speaker?
I'm intrigued with this, the summary of switching and dates of action. And I look at the year and the number of switches that were made. Mr. Walker, what year did you become chairman?
12 or 13, I'm not sure.
Before that date, does anybody have how many leases were granted between 1995 and 2010?
We can generate that list.
Okay, well, how about how many leases have been granted since you assumed power over the Department of Land Management and the Chamorro Land Trust? I mean, in the last 8 years, surely somebody...
Well, last year there were, I think, 235.
What I'm trying to point out is that prior to 2010, there were all of 6 transfers, or what they called switches. 24 switches were made within the last 6 years. So I'm trying to figure out whether with the 24 switches there was the bulk of the leases were signed over these years. I don't think so, because when I remember having oversight hearings before you came on, we were getting pretty close to the 2000 mark, even in 2009, and at that point we only had 6 switches, and in the last 8 years it's 24 switches. And how many of those how many leases did you guys do as a result?
I can get that information in detail.
Can you? And the other thing that I'm intrigued with on this list is, well, one, how many for 2018 you only have 3 switches, or at least on this list. How many of those 3 switches were Barrigada Heights recipients?
I think Exhibit 8 will probably give you, no, I'll take it back. One of the exhibits may have the details. They all list the properties.
If you look at that same summary that you're looking at, the 2018 switches, it shows when the switch was approved, and then if you follow along the column, it tells you the applicants that were involved in the switch, and then the last column tells you if a lease was issued or not.
And also, I'm trying to get an understanding of why the switch was made and then no lease was issued. And I know we tried to cover for Mr. Camacho or the deputy, but that you were mentioning that he was acting for an extended period over the last 8 years. But some of these the last 6 were within the last year. The last 10 were within the last year. And I don't remember you being gone for such a long period, that from January 2017 until April of 2018, there were 10 transfers. Were you aware of those transfers?
As I mentioned in the hearing, in our meeting last week, I was aware of transfers. A lot of these transfers are really for compassion reasons. We get people coming in who I think you heard testimony, in fact, last Tuesday about this, where an individual who's lived this 23 years and still not gotten their lease now has children who are more in need of the property than they are and have come in to ask for that for a variety of different reasons. And that's the kind of the compassion that we had looked at to try and assist with constituents.
But there were, on this one, in the last year, there were 10 switches and 6 didn't get leases. I'm trying to figure out why
it
they
may still be work in progress. We had not concluded it.
Okay. And I can't remember, did I get an answer on how many of the switches received Barrigada Heights lots?
No, but we'll get you that number.
There's 3 switches that have Barrigada Heights leases.
And those are the 3 names that are on this short list?
Yes. Yes, they are on that list. Let's see. Number 24, number 21, and number 20.
It's not complete. I'll tell you offline which one I can see is not on this. Thank you.
All right, thank you very much.
But what we'll also note on that list is that some of these switches, in fact, one of them he even admitted is an employee of the department, but that was after a 7-year period where the individual relinquished his lease over to a niece after the 7-year period that's allowed.
I'm sorry, Speaker Cruz, I didn't catch your last comment about it. The list is not complete. The lease is listed. The lease is listed as
At least from my
income.
recollection of those that received property in Barrigada Heights, I don't think this list is complete. Thank you.
Okay.
I think I've exhausted my time.
Thank you.
Thank you very much. Senator Nelson?
Thank you, Mr. Chair. I just want to go back again into the testimony. In the bypass list that you mentioned, you found 2 levels where the policy was not followed or the policy failed to address. One, there was no oversight to ensure that land agents were following through with contacting and mailing each applicant, waiting in line before moving on to the next eligible applicant. And 2, no notice was provided to 1995 applicants that this policy was in effect. And so in this bypass list, you say that there are 4,707 applicants who have not received leases, but I don't really have an understanding of the count of how many people were bypassed. Is it the same amount?
Yes, all of them have been. In fact, if we wanted to look at the entire bypass list, that means we have to look at the applicant with the latest date and time that has a lease and look at everybody above them that does not have a lease. That latest applicant date and time, if I'm not mistaken, is 2016. So anybody that's applied before 2016 has technically been bypassed.
Okay. Corrective action moving forward, it didn't really say, I know you're going to have an audit, but what will be done for these people that were bypassed, and how will you determine if they were either just fairly bypassed or if some people names were thrown in depending on who was in charge of the Department of Land Management and the approving authority?
I believe the first thing we want to do and we're proposing to do is to publish the bypass list for 1995. Because when we publish it and we follow through with section 5.10, we will be able to clean up our entire bypass list and figure out and remove those names of individuals that do not respond. And I think once we can remove those names, then we're left with a current list of people that have been bypassed.
Who will do all this work?
The commission staff.
And how many are there?
I believe there's eight or nine. 9 staff.
Okay.
The publishing of the bypass list and all the work that
You have to
comes
contact
along
them,
with
no?
it,
Yeah.
it's significant.
Yeah, it
but
is.
at this point, we're not issuing leases, and all of the work that they had been doing, working with applicants to get them a lease, has been suspended. And
Okay.
all of the staff's efforts will be focused on that initiative.
Okay. And maybe perhaps I'm going a little bit too far forward, but some of the challenges with the land for land list is some of the property that were given to them were unable to be built upon due to terrain or whatnot. Are you looking at a different approach when you start approving leases again once more if there's perhaps a subdivision, a form, and a place to get infrastructure for the people? Is there a plan, and are you considering a plan for that also?
Yes. Our vision, if you may have it, is that when we do start issuing leases again, they will be done all at once. So right now, when leases are given out, or before all this happened, the way leases were given out is we'd call an applicant would come in, we'd say, what village do you want to live in? And then we would entertain them that way. And it was a very cumbersome and haphazard way to assign lots to our applicants. In the past, what the commission had done was to lease the entire subdivision at once. And our hope is that moving forward, we will be able to take that, to be able to actually plan the community and lease the entire subdivision in a way that we're having the applicants move on to a piece of property that
They can develop on.
yes,
They can build.
right.
Okay, and what is the timeline for you being able to start moving forward with the leases? Have you guys discussed that yet, a possible timeline? And just to caveat onto that, this means all Chamorro Land Trust lands. So it's not just for residential, agricultural. It's even something that we need to consider as a body at the legislature, saying if bills come forward and it's asking for Chamorro Land Trust property, we need to consider the situation that the commission is in, right?
Yes, thank
Okay.
you. We'd appreciate that.
Okay, thank you.
Thank you.
Thank you very much, Senator. Senator Rogan?
Thank you, Mr. Chair. Madam Chair, how many members of the commission is required for a quorum?
3.
3 members? And the reason why I asked that is because I noticed that in your presentation, and I thank you for sharing it with the members of the committee, that your next commission meeting is scheduled for the 21st of June. July 19th is your subsequent scheduled commission meeting, and that has been canceled due to the anticipated lack of quorum. And then the next progress update would be on August 16th. Is there anything that prohibits the commission from meeting, let's say in July, at a different timeline and date, so that in fact you don't bypass a commission meeting, considering the urgency of the situation that you're working with?
Understood. I myself will be unavailable the entire month of June and July, so that leaves 4. And I know that our vice chair has also submitted his time for off-island, and I'm not sure what those dates are. And also another of our commissioners will be off-island at that scheduled July 19th commission meeting. But I do want to reassure you that throughout this entire period, the commission members that are still here on island will be working with the administrative director and the staff, and will be providing updates to myself and the vice chair throughout this period.
And I just bring that up because I think that with the sense of urgency and coming up with possible initiatives from this body, that certainly having a meeting without skipping a month would be appropriate. I think that also without using the term moratorium, I want to thank the commission for making a decision that any future leases will be suspended or has been suspended, any consideration of future leases unto such time that you review all of this information. Because certainly when we're looking at a list that's reflective of extensive list of bypassed individuals and applicants, certainly you need to purge that particular listing based on the process allowable by law. But subsequent to the purging of that list, really it's going back to the individuals based on a first come, first served basis. So I thank you for recognizing that and suspending any further consideration of land leases until such time that at least everything is open, everything is transparent, and the people, the applicants understand that if in fact they're the next individual on the list, then the next available property would be provided. So thank you very much. Thank you, Mr. Chair.
Thank you, Senator. Vice Speaker?
Just a very minor question. When you transfer a lease or you switch a lease, do you execute a new lease? Because you said that the deputy director did not execute any leases, but that he approved several of the switches. So what does that mean? That he didn't sign a lease for those switches?
Correct. Within each of those applicant files that were switched, there was approval from the deputy director. They were switching application rights, the date and the time. And that's why we had to look at each one of those switches and see if a lease was involved at the time of the switch or if the lease came after the switch.
Oh, okay, I guess I apologize, and this is the first time I'm realizing there's a difference between a switch of application ranking and a transfer of the lease. Those are two separate things. All right, I get it. Thank you very much.
Thank you, Vice Speaker. Senator Lee? All right, thank you. We're going to go ahead and continue then. Regarding this alpha listing that you say is on your website, is that just sorted alphabetically, or because I noticed like in the exhibits that you provided, it does not show. It shows the date of the application. It shows the type of lease that they got, whether it was residential or agriculture, but it doesn't say whether I am number 3,000 on the list or number 3 on the list. So I don't know if that's a column that was just erased or what.
It was just a listing of all the applications that we have. It was just the complete listing. And we're trying to work where we can make a listing that's releasable, because there's some privacy information in there we don't want to give, but to make it also usable where you can actually resort.
Right.
So you can look at it in different ways as well.
Okay. So the database that you have on your website is simply an alpha listing. So
who's on the list, so you can find your name on there.
And okay. So I'm not sure. So it doesn't really tell me where I am on the list then. It doesn't tell me whether I am number 10.
Well, that's why it would be better if we can switch it around. Well, we're still working on it. What we did is we just provided a listing, not sequential by the date and time, but we want something where they can work on it, because it's not listed numerically 1 through 12,000 of sorts. You can sort it by the date and time of your application, and that's where you know where you sit on that list.
Well, yeah, but when you put it on your website, the person that's viewing it is going to probably be looking at a PDF file and is not going to be able to sort it.
Right, and that's what we're working on, to get some kind of file that you can be sortable. You can sort yourself.
Well, all right. Well, we'll talk a little bit more about the details of that. I was thinking of something like, I want to be able to take a look at the list and look for my name. That okay, I'm number 8,000, okay. And just to get an idea of how close close I am to getting, a piece of the rock. I have some questions. In reviewing the rules and regulations, if you take a look at Rule 6.6, it implies that an individual can be awarded a lease for a residential lot and an agricultural lot. Now, I was trying to find something like that in the exhibits that you gave, so I just didn't see any names where a John Doe is shown as having applied in 1995 for a residential lot and agriculture. But in Rule 6.6, it's very clear. It says that a lessee possessing a residential tract lease may construct a residence on the lessee's agricultural tract. So it implies that an individual can be awarded a residential and an agricultural tract. And so this is something that definitely we would be looking at, and of course with recommendations from the CLTC as to whether that's going to, given the fact that the number of lots available and the number of applicants, there is a larger demand than there is supply of available land. So that may have to be looked at. There's Rule 7.3 regarding building requirements. And it says that if an applicant is awarded a lease, CLTC, and before you go out and build a house, CLTC has to review the plans and other stuff. And I wonder if CLTC has the expertise or the manpower to be reviewing building plans. Maybe that's best left to DPW.
Correct, and that simple answer is no, we don't have the manpower. And that's examples of things that probably need to be modified in that old rules and regs and in those old laws as well.
Right. So I point out that Rule 7.3 is something that the Commission may want to take a look at. I would also like to point out Rule 7.5 regarding the transfer of leases. In that particular rule, it says that after holding a lease for 7 years, I can transfer it. And it says I can transfer it to any individual who qualifies and is at least 18 years old. So it doesn't have to be a family member. I can transfer it to a friend who meets the qualifications. In contrast, we see that, for example, in Rule 5.8, it's pretty tight about who can succeed to those application rights. It's got to be within the family. There's Rule 10, which allows for community pastures of up to 20 acres. I'm not aware of anybody that's raising cattle, so maybe that's something that maybe should be considered for deletion from the rules and regulations. I think at the oversight hearing the other night was a very good example that was brought up where an individual applied in 1995, but it's been 20 years now. He wasn't going to wait around for Chamorro Land Trust. He went and he got himself a piece of property, built a house on it. It's not really depending on that award of that Chamorro Land Trust property. However, he has a daughter who certainly is ready to build now, but she came in and applied later, and so certainly the ideal situation for them is to be able to switch, and maybe that is the legislative. That's where legislation will be required, and something like that we probably need to consider sooner than later until we wait for all these analyses to be done. finally, the issue about priority standing. I hope that the Commission will take a look at that to see if that really is still, because obviously I think it works in a rather weird way, because the harder you work, you get penalized for it. So if I signed up today and I don't have any land, I'm priority 1. But if I have to wait, like many people have, for 20 years, they go out and they work hard, they go and manage to get a piece of land and build a house, now they are priority 3, at least by that definition. So that individual gets penalized for having worked hard. And we, I think, need to take a look at the priority standings criteria that's it's in Rule 5.7, or I'm sorry, 6.2. In Rule 5.8, it's interesting how that Rule 5.8 has to do with the order of succession. So if the lessee dies, the law is very clear as to the order of succession. It goes, so if the husband dies, it goes to the wife, or it can succeed down to the wife, to the children, to the widows or the widowers of his brothers and sisters, the nieces and nephews. But the grandchildren or the siblings of the lessee are not in that order. So I would urge the Commission to take a look at Rule 5.8 and really think about that. And finally, I would urge the Commission to take a close look at Rule 5.8A3. We have situations where the original leaseholder is a qualified chamorro who marries a non-chamorro. The qualified applicant passes away, and so now you're left with the spouse, the surviving spouse, who's not a chamorro, and by law then is not eligible to succeed with that property. And I believe there's been a couple of cases where basically the surviving spouse may have to move off. So I think Rule 5.8A3.
But if I may, Senator, I think the rule also specifies that in the event the surviving spouse is ineligible, then the child can be considered.
But if there's no children,
right,
then that becomes problematic. Okay, I'll stop for now. Speaker.
I won't follow up on those questions with the current case in court. I'll ask a very simple question. What is your website? I'm trying to find it.
DLM.guam.gov, and then there will be a Chamorro Land Trust link in there.
Just so the people out there can follow it. Under that, there's a thing for Chamorro Land Trust Commission, and that's where we would find is there the questions that the chairman was asking about the listing. I
think that list got put under announcements or a couple different places there. There is room for much modification to our websites, but it's not really our website per se, as opposed to the GovGuam type of website setup. And we're working on that as well, but it had actually improved since before. But it could be more user-friendly, and we acknowledge that.
Okay. Because that's, when we were talking about trying to reach out, though I'm very disadvantaged, I don't know how to use these things, it would seem to me that others might be able to or could be able to, but it just isn't, it just isn't friendly.
Right. So we had discussed this too in trying to do something as well moving forward to make it more friendly and to actually even have forms available and other ways to interact, to get the updated information straight to us as quickly and as easily as possible for them, with an acknowledgement that we received their information, so that they knew they had proof that they made that contact and that they would not be eliminated from the list for failure to contact. So those are the kinds of things we have been discussing, but it's really been a very short time in this process so far.
Is the commission planning on on meeting to ratify the voidable contract, the voidable leases?
That is the direction we are moving for those without questions.
Okay, thank you.
Thank you very much. Senator Reagan?
Thank you very much, Mr. Chairman. Just a recommendation. I did propose that administrative rules and regulations be formulated as a result of some of the changes that are necessary. And I noticed that in some of your decisions, and obviously I was present at that meeting, some of the decisions, the policy decisions that you made at the commission level easily could be changed at the next commission meeting, as long as there's a quorum. So I would recommend, as the chairman is suggesting, that you take a look at some of the provisions contained in Public Law 23-38, that some of those policy decisions also be recommended in terms of updating the provisions contained in Public Law 23-38, because that's where you ensure and you assure the applicants and the members, the potential beneficiaries of the Chamorro Land Trust Commission, that these are rules and regs, these are laws, they have to be followed by commission members as well as all of the staff members. So I would recommend certainly that you consider that and incorporate it as rules and regulations formulated by the commission so that it's consistent in the application and the release of additional properties. So thank you very much. Thank you, Mr. Chair.
Thank you, Senator Reagan. Senator Nelson? None? Vice Speaker? Senator Lee?
Thank you, Mr. Chair. Mr. Borja, I'm not sure if this was covered in the list of things that the chair had asked for you to provide for the committee, but if you could also please provide the committee with a list by sequential standing, that would be helpful for us. Thank you.
Finish? Sorry. Okay, let's start the next round here. In the rules and regs, I would urge the commission to take a look at Rule 6.3. 6.3 pertains to the award of leases and the lessee's performance, ability to perform. The way it reads is that the commission shall enter into a lease with any applicant who, in the opinion of the commission, is qualified to perform the conditions of such lease. And then it says that whether an applicant is qualified is determined by the following. he has an approved loan or financing for the construction of a residence or a conditional letter of intent. He has a contract between there's a contract between the applicant and a construction company. So basically the ability to perform is one of, does he have the economic capacity to build a house on that residential lot? But what's interesting is, and of course I think that would be, but what's interesting is that the same thing is not required of somebody who gets issued an agricultural lot, which normally is a lot bigger, right? So an individual who applies for a residential lot will probably be, depending on where it's at, probably up to no more than an acre. However, somebody can come in and says, I want an agricultural lot and I want 2 acres. But there's no requirement for him or her to demonstrate that they have the ability to farm 2 acres. So I would urge the commission to take a look and start considering the requirement to determine if somebody has the ability to farm 2 acres of land. You know, if they're not even gardening, and then you're going to give them 2 acres. And those are the only other rules that I've taken a look at that I would urge the commission to begin taking a look at, and I guess I'm signaling what might possibly be coming out for legislation to suggest, to make improvements to the program 20 years later.
And I'd just like to note, too, that, you know, the rules and regulations were written over 20 years ago before they were, without the practical applicability of those rules and regs. And so as we have now learned over all these past 2 decades of the practical part of it, there may be some parts in there that do need to be modified, because it does get very strict in there. You know, you got to build a typhoon-proof home, or you got to build within 1 year. Failure to do so is a default. Do we really want to default these people for the inability to do something within 1 year when they don't even have access or infrastructure? So, you know, those are the kinds of things where, you know, I've never seen it tackled at all. But I do know that, you know, they did their best to make these rules and regs. Senator Angel Santos, and I believe your chief of staff at the time was the administrative director, put a lot of effort in. There were many public hearings in that process. And they did a great job in putting these rules and regs together at the time, but no updates have been made to them at all. And so it probably definitely is the time to make it more practical and make it more sensible to today's actual use, still staying within the parameters of the law.
Madam Chair?
If I may draw your attention to section 5.6. Letter C, it states that an applicant who is awarded a lot shall be able to decline lots in 2 different villages. After declining a 3rd award, applicant's name shall be removed from the waiting list. We'll be looking at this provision in the law as well, because when this is in practice, what it means is our land agents spend a lot of time with our applicant, get them out on a lot, we get a lease, everything's good, they have every right to come back anytime and decline that lease and go for another one. And so we'll be looking at that to see, I guess, to keep the intent there, but make it applicable to the way that things work.
Okay, thank you. Speaker, no more? Senator Nelson, Senator Reagan?
Just a couple of things. Thank you very much, Mr. Chairman. First of all, the declarations that's required by staff, I think it's not only appropriate, but I think you should take it a little further, so that any individual that within 2 consanguinity of relationship really should not be entertaining an application that that they have that familiar relationship. That will safeguard the commission and make sure that there's no questions of impropriety or favoritism. The other one is, Madam Chair, I would recommend that you refine your numbers, please, because in your testimony today, you mentioned 2,431 leases that have been released. In the media, you stated 2,461 leases that were released, and then tonight, you highlighted 2,978. I know where you got your 2,978 tonight based on the numbers that have been presented, but I strongly recommend that you refine those numbers so that in fact it's consistent. And then finally, Mr. Borja, you know, you alluded to maybe it's time to revisit the rules and change it. That's in your arena. So if you feel compelled that it's time to change the rules, then promulgate it and get it to this legislative body through the governor's office to this legislative body so that it can be passed and the appropriate changes would address some of the program concerns that you just alluded to. So I would strongly recommend you move in that direction. Thank you, Mr. Chairman.
Will do.
Thank you, Senator Hagan.
Thank you. I just also want to point out 75108 of Title 21 also specifies like requirements for agricultural leases, the use of agricultural lands. It says you have to cultivate or farm within 1 year, and then it's very detailed as to how many plants you have to put, things like that. But could we also get a list? This thing about, I realized when they combined the Chamorro Land Trust under the Department of Land Management, it was to share resources. So maybe a description of resources that are shared and particularly surveyors. Are they shared or do you have separate surveyors? Just clarify that for us. And also if you could make a list of land that has been transferred out of the inventory, either by public law or some other way, and to who it was transferred. Thank you.
Transferred as in was sent to another agency?
Correct.
That kind of information?
Yes.
Sure.
And whether there was compensation.
Okay.
Thank you.
All right. I don't have any further questions. If any other members have questions?
Oh, could you just introduce your board members for the public since we've got this on the air? Is that okay, Mr. Chair? Because I see them here and I just, oh, sorry, did one leave? Shoot. Just so that everyone knows their faces and their names one more time, if that, I think that would be helpful. Sure. Can you introduce yourself?
My name is Joseph Cruz, Vice Chairman for the Commission.
And then we have Ms. Chantel Teixeira, one of the two newest commission members. She's sat on the commission for the last 2 meetings.
Half a day. I am Chantel Teixeira.
So sorry, my name is Austin Duenas.
Austin is one of the new members also. That's okay. And in the back there is Mrs. Amanda Santos, the mother of the senator that introduced Public Law 2338. Okay. That's 5. Yeah, 5. Okay. So then, if there's being no further questions, the Committee on Land, Environment, Agriculture, and Procurement Reform will recess this oversight hearing until next Tuesday, May 29th, at 5 p.m., where we'll be discussing the program revenues and expenditures.